All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention. You shall be heard. God save these United States, great state of Florida, honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case for the day is Yuloa versus CMI. You may proceed.
Good morning. May it please the court, my name is William Pinnell and I represent the petitioners in this case. Please reserve 4 minutes of my time for rebuttal. A couple of facts in this case. The trial court found that the source code for the software version 8100.27 of the Intoxilyzer 8000 machines, which are created by CMI, the respondent in this case, and used to test each of the petitioner's breath in this case, they found that to be material and granted the petitioner's authority to issue subpoenas ducis tecum to CMI through the registered agent of Florida.
Could we cut through a lot of this and go right to what I have a concern? You know, I'm very sympathetic to your position. It seems odd that you may have a situation where someone can be incarcerated and equipment that's brought into the state that's utilized to do that, and it's like, you know, well, how do I find out about this stuff? But if the uniform law does not apply, and we look at the cases where the 3rd District is held in one earlier case, does not apply, then what authority do we have to apply to get this information?
Your Honor, there's several statutes under Florida law which provide authority for the petitioners in this case.
Other than the service of process and jurisdictional?
I believe Florida Statute 607.15101 provides authority to serve the registered agent of a foreign corporation authorized to do business in this state and who is actually doing business in this state.
But is that for discovery? Is that for the purposes of a legal action, that you're going to be a party to a legal action in Florida according to our rules?
I believe pursuant to the rules and the statute, it applies to both, and that's consistent with the decision of General Motors and the 3rd DCA.
So then you would be able to use the registered agent to compel witness testimony from any out-of-state corporate witness?
Your Honor,
because you're saying, in other words, you're the same rationale that once they have a registered agent here, that essentially makes, you're saying that registered agent transforms them into being present in this state for all purposes. Is that what is that your argument?
Your Honor, the corporation is present in the state, not individuals. I think there may be a different analysis if the
But the documents here are not, I mean, you're not contesting, and I don't, if it would be different. If the documents were here, we wouldn't be here, correct? If the documents were physically in Florida.
Sure, Your Honor.
You'd be able to subpoena them in a normal subpoena ducis tecum. But the documents are in Kentucky, and Kentucky actually has ruled that these documents are protected, and the 3rd District has said these documents are immaterial, but we're not there for that reason. My concern is that what is it, and going back to what Justice Lewis is saying, you're saying the authority to be able to serve a subpoena for documents out of state is the fact of a resident agent. Is that, I mean, that's the argument.
Your Honor, first of all, I don't think the record shows where the documents are located, and I don't think the lower court's decisions anywhere in the record suggest that they're out of state. I think it's unclear.
Well, if they're in the state, then we don't have a controversy. I mean, if the documents are in Florida, then you can just serve a regular old ducis tecum on the records custodian that has the records.
I understand, Your Honor, but it's our position that the corporation is present in the state because it's doing business, is authorized to do business, and has a registered agent in Florida. And we think there's a distinction between subpoenaing a live witness who's out of state and the corporation just to produce the documents who's in the state.
And what says that? That's what I'm getting to, because the Uniform Act covers documents and testimony. In some cases have drawn a distinction on that, but that's what gives the authority for just the documents?
Well, the uniform law, the Florida version of the uniform law only addresses testimony. There's no
I
indication.
understand, but what gives authority for the documents? You're saying if we don't ask them to testify.
Because we're not asking a witness that's not located in Florida.
Fine.
Sure.
On what authority can you get the documents from out of state?
I think the statute.
Just the 607, you come back to the 607, you're doing business.
607, and then there's various provisions of Chapter 48 that I think provide.
Well, that serves the process for a legal action, isn't it?
I think it's process for I think this is a legal action, and I think that 607.
Wait.
Go ahead.
You have not filed a legal action against that corporation. This is discovery. They're not a party. A party makes a difference, don't you think?
I think it could, but the court did make a finding that it was material and did give.
Well, I don't disagree with all that.
Sure.
Again, I'm trying to hit where the authority is that because courts in jurisdiction, courts can't just willy-nilly just haul off and do things across state lines, even though it seems to make common sense that you ought to under this circumstance.
Your Honor, it's our position that we're not crossing state lines in this case because they are present here in Florida, the corporation itself.
But what about, how are you going to, what is the authority of the court actually if the resident agent ignores the subpoena because the resident agent doesn't have the documents? How can we enforce that? How can the Florida court enforce that subpoena?
Well, under the statute, Your Honor, the 607-1505 subsection 2, it indicates that a foreign corporation who's authorized to practice business in Florida is subject to the same duties, restrictions, penalties, and liabilities now or later imposed on domestic corporations of like character. So it's our
are you
position.
saying that the sheriff of whatever county this was filed in can go to Kentucky and get these documents?
I think pursuant to the statute, the court in this case would have some authority to impose sanctions or enforce the subpoena ducis tecum under that statute.
Well, but the subpoena, now there are three of the, and this is sort of a crazy thing. Apparently 18 of your colleagues decided that to do this, they'd ask for witness testimony and subpoena ducis tecum. 3 supposedly asked only for a subpoena ducis tecum. In my way, and I mostly did civil cases, there would be a records custodian. Documents just don't appear out of thin air unless you're, again, party and you're doing a request for documents. But they asked that CMI's records, custodian of records in care of NRAI Services, Inc., which is apparently the designated registered agent, must be one of these just agents that do that for their business. They're not real. They're not like a real agent as far as an employee, to appear at the offices of issuing counsel and bring with him all source codes for the Intoxilyzer 800 software. Now, if the records, so you were actually asking not the registered agent to bring the documents, because again, if the registered agent had the documents, I think you'd be in a different situation. You're asking CMI's custodian of records. That's a witness. A witness is bringing documents. So that's what I'm trying to understand. What's the authority other than you say, well, this registered agent to get documents that are apparently located in Kentucky?
Again, Your Honor, I don't think the record suggests that they're in Kentucky. I don't
Well,
think
if they're here, see, this is the point. If the records are here, then we have no reason to be here in this court. It's like you suggest, or the amicus, that Hospital Corporation of America is a foreign corporation, that somehow someone couldn't get records of hospitals that are located in Florida. That's like, of course they can. You can get hospital records of hospitals that are in Florida. If you were, let me ask you this question, hospitals. Say you wanted to get a hospital record from that was in Kentucky, but it was through Hospital Corporation of America, and they were doing business in Florida. Could you serve their registered agent and get the hospital records located in Kentucky of say a witness that was going to testify, and get them through serving the registered agent of the of Hospital Corporation of America because they were doing business in Florida?
the records are in Kentucky, and the lawsuit's in.
It's one of your, somebody there, the state's going to have a witness testify. You want to get the witness's records.
I think under the law, under 607, Chapter 48, we could, yes. I think so.
Now, what would you have to do if they don't have a registered agent? Is there a way in a criminal case, because you have a right to compel witnesses, do you have a way to go and get this source code, assuming, again, the Kentucky allows you to get it? What way would you otherwise go to get this information?
I mean, one of the ways is through the uniform law. You could ask for testimony and documents, but I don't think you're required to.
Okay, so if you can't take advantage of the uniform law, then how else do you go get the documents?
I'm not sure, Your Honor, and then that's not the facts of this case, but I'm not exactly sure. I think you
Well,
could go out of state and somehow serve them out of state.
Of course, you can go to the state that has the records, and you go through that state's laws.
Procedure, sure. Again, I think because of the unique facts of this case, where it's only production of documents, and going back to Your Honor's discussion of the subpoenas.
So you're trying to evade the uniform law by, that's what I still can't understand how this could happen. You're trying to evade the uniform law by saying that we are only trying to get documents from this out-of-state corporation, not get witness testimony. I just don't see where how that allows a trial court in Florida to reach beyond its territorial limits to authorize a subpoena for documents that are in another state.
Two reasons, Your Honor. The plain language of the statute, the Florida version of the uniform law, talks about testimony. So we're interpreting the plain language of the statute, so I think the uniform law does not apply because it's only documents. And secondly, there's nothing in the uniform law that says that's the exclusive means of affecting service. Nothing in that statute that says that's the only way you can do it. And even the Bastos case says that's one way to do it. It's authorized, does not say there's not another way to do it under Florida law. It's our contention under Florida law that the statute, the plain language of the statutes, 607 and Chapter 48, allow the subpoenas to be served in this manner, and that they were lawfully served in this case. I'd reserve the last minute and 15 seconds for my rebuttal. Thank you.
May it please the Court, Robert Harrison. I'm here on behalf of the Florida Association of Criminal Defense Lawyers.
Could you answer the last question, which is in a situation where there's not a registered agent, and you need, and we get this a lot in death cases, you need records from another state. What is the process that is followed to get those records?
Well, if we were, one way would be if they're doing business here, you could, if there was a registered agent, you could do that. Your question, if there's not a registered agent, if you're doing business here, I believe you potentially could do service through the Secretary of State. I believe you probably could go like in the civil rules and get a commission and go to the other state if the Uniform Act applied. So there's several ways to get the records. But if I can go back, Justice Parente, to your question, when we talk about the location of the documents, whether they're in Florida or Kentucky, I don't believe that that's important. Because let's do the example. If I had a Florida corporation and they store their records in Georgia, and I was able to serve a subpoena on the Florida corporation here in Florida, they would have to bring those records from Georgia. They can't, so the key here is, do we have, has the corporation been
Well,
lawfully
let me just
served?
go over this. This is we're dealing with a criminal case,
Correct.
and it's a Florida corporation, but the records are located,
Out of state.
and the records custodian, where's the records custodian?
There may be a custodian of records in both states. I don't know.
But the records and the records custodian are out of state. You're saying that a subpoena in this state, not to get the out-of-state witness, but to get the out-of-state documents, can be served and compel somebody in another, where documents are in another state, to bring them here and they're not involved in the lawsuit, they're a non-party?
Because I'm going to read a quote from the General Motors case, even though it was a lower court, but it cited to another authority, said the subpoena ducis tecum issued by a court consequently reaches all documents under the control of the party required to produce them, even if those documents are located outside the territorial jurisdiction.
But didn't you say parties? These are non-parties, right?
Well, whoever is served, it
matters whether it's a party or a non-party witness. If the corporation is in the state, we obviously have jurisdiction over that corporation.
That is correct. And where we have dealing with CMI, so if we had, and the reason I use that analogy, if it was a Florida corporation and we served a subpoena on the registered agent here in Florida, because that's how you serve the Florida corporation, the court has authority over that corporation, and the corporation can't avoid production by storing their records up in Thomasville as opposed to in Leon County. And likewise, and the key is, do we have a proper subpoena that's served on them? And under the Corporate Act, when a foreign corporation comes here in Florida, they have the same rights, liabilities, privileges of a foreign corporation.
But I just want to make sure we're not, because if you're saying that CMI, and this is certainly an allegation, had the records here, but intentionally brought them to another state, we'd have a different case, wouldn't we? I don't see. I've read the briefs, and it's a very slim record, and there's no allegation that I understand that these records were located in Florida and then were taken to another state to avoid production.
Yeah.
Is that,
I agree. We have a slim record, but
is that,
I can't
you're taking a situation. If a corporation tries to hide records that were located in Florida, then that's a different case.
But the key is, once we get them lawfully served, once they're here, you have the authority over the corporation. So the question is, did we lawfully serve that company? And so whether you're a Florida corporation or when you come here to this state to do business and they're served a subpoena, the court has the authority over them, and they have to produce documents whether they're inside the state or outside the state. Otherwise, they could potentially play the hide game. We go to Kentucky. Oh, well, we actually have a storage facility. It's in Indiana. We don't have to do that. Once we serve that company, they
Well, certainly
have to
I
produce
agree
it.
in a civil lawsuit, and they cannot do that. I think what we're talking about, and we're in the criminal law here, and we've got obviously the rights of the clients, the defendants, to get relevant material information. But we're also dealing with the fact that you're trying to transform a registered agent for purposes of service of process in a lawsuit into something that there is no indication that the legislature ever intended occur, which is to become a plenary, to transform a registered agent into plenary presence as if they were here for all purposes. And in my view, that would mean they'd have to respond to subpoenas for witnesses, because I don't see where the documents become something where you can produce those, but you don't have to produce the witnesses.
Our position is not based upon the fact that they have a registered agent. That's secondary. The fact is that CMI is doing business here in Florida. And because they're doing business here in Florida, that's why they have a registered agent.
So if they didn't have a registered agent for whatever reason, are you saying you could send a subpoena to the company?
If they're doing...
Because you said that doesn't matter.
Well, the registered agent is how we perfected the service. And since that's allowed by statute, how you would serve a foreign corporation doing business here in Florida. But what gives the court the initial jurisdiction over them is because they're doing business here in Florida. Now, when you're doing business here in Florida, you're supposed to have a registered agent. If they neglected their duties and didn't have a registered agent, the Corporate Act would give the alternative service process, which I believe is to the
So it
Secretary of State.
doesn't matter that the registered agent is not the custodian of the record?
That is correct, because once the court, that's the manner that they're served. Once the court has jurisdiction over CMI.
So then I understand, why couldn't you get the witness, why couldn't the same process go and you'd have to compel them to give witness testimony?
If I wanted to have witness testimony, now I'm asking for an individual. If I wanted to...
But you did ask, you asked for the records custodian. Records just don't, again, in a civil case, you get a request for production, but records are attached to who has possession of those records in order to authenticate the records. It's not like they exist in a vacuum.
Yeah. They would have the option to either show up with the records, or they could have delivered the records in advance, and that's the way that the documents are set forth. And that's certainly, the reason for the procedure, whether it's documents or person. We were certainly following the roadmap that was set forth in the General Motors decision.
So what's the remedy if they don't produce them?
If they don't produce it, the enforcement, and I wrote this down to talk about that, is you could do, and actually this actually did happen in Sarasota County, and there's a second district case, CMI versus Fabian, where the Sarasota County judges imposed a coercive fine. They said you're going to be fined $100 a day until you comply with a subpoena, and that was affirmed by the circuit court and by the second DCA. So could you actually send the sheriff out there to get the documents in Kentucky? No, but you could impose a daily coercive fine, because in fact that has happened and it was upheld on appeal.
Thank you for your arguments.
Okay, thank you.
Good morning. May it please the court, Edward Geddes on behalf of CMI.
Can I just in terms of what's happening with these documents?
Yes, ma'am.
Because this is obviously the underlying issue. In Kentucky, apparently, they've been held to be not producible. In Miami and 3rd District with the Bastos case, they've been held not to be material, but in the 2nd District, they've already been produced? I mean, I'm just trying to see if I understand we've got a legal principle here,
Right.
but at some point, we're also here to try to do justice, and if the source code is, in fact, shows that the breathalyzer is not reliable, then we really want to get and search for the truth here. So, I mean, I think the principle's important, but...
To answer your question, Justice Periente, I have to go outside the record.
But it looks like in the 2nd District, they're...
And I want to be clear about that, because I don't want to misrepresent what the record
Well,
is.
then don't go outside the record.
It's what was decided at the second DCA in Landrum was nothing more than whether or not the validity of the subpoena on the registered agent was proper. It was construed in a felony context, where, in other words, we originated in the circuit court. It went up to the second DCA on a first-tier cert. The second DCA said, well, the trial court followed General Motors. End of our analysis. We're done, without getting into the inquiry that the court is engaging in today. So it has not, I will state, and I think this is really a matter of public record throughout the state, CMI has never produced the source code, certainly in its electronic format, anywhere in the state of Florida. It made available temporarily in, I forget if it was Clay or Escambia County, a written version on a flash drive that was provided in the state attorney's office subject to a confidentiality order, and then it was returned to Kentucky when the review was done. That's it.
Just would sure be nice to work this out, and not in
and,
some
and,
way
and
that
again,
is...
I would go further and further outside the record to address it.
Don't do that. Let's go to the legal issue.
But I think the court has honed in on the very issue that is CMI's position.
Do you take a position, though, there are some courts that say that you can't even, the Uniform Act only applies to witness testimony. It doesn't apply to documents. What is CMI's position about whether it applies to both?
Well, I think it should be interpreted to apply to both. I will agree that the language of the statute, as written, does not address documents. It addresses testimony.
It doesn't even address testimony
In conjunction with documents. Nonetheless, Florida courts, various Florida DCAs, have interpreted that same language to say, well, concomitant with that authority is also the authority to request that documents be brought along for the testimony. Other states that have enacted the Uniform Act, and this has been enacted by all 50 states, all of those jurisdictions that have examined the question have said it reaches documents, notwithstanding the language that says testimony. And
Again, if it doesn't reach documents, then there is no other authority.
And that's why CMI is not taking the position on appeal or in these proceedings saying this court should simply tell the petitioners they're completely out of luck. I think the more appropriate, the just approach is to interpret the uniform law in Florida as it has been interpreted in other states so that it reaches document requests. Because if not, there is no mechanism.
Well, let's slice this up. It seems to me that you could certainly be within an area that in Florida, the law of this state would be that X producible, X is discoverable, X is material, X is essential in this litigation and to the liberty and freedom of one of its citizens. Mm-hmm. And then we look at Kentucky or Mozambique, and it says X is proprietary, cannot be disclosed for any reason. Are you suggesting then we're just in a conundrum that's unanswerable? Or why couldn't the state of Florida take whatever action, may not be able to go into Mozambique and get the documents, but could certainly take whatever action is necessary within its own borders to, and by way of fines or whatever. Maybe couldn't even enforce those. But whatever it is within their own jurisdiction, mm-hmm. because they have filed a registered agent indicating they're doing business in the state, why could they not take action against that individual, whatever's going on within their own state? May never lead to the documents, but the entity that is suggesting that you can't touch this, you'll no longer do business in this jurisdiction.
To answer your question, Justice Lewis,
kind of a lot of questions.
It was a long question. I'm
yes,
processing the different phrases.
Well, what I'm
in
trying to see.
No, I understand the gist.
We're at loggerheads, and justice demands in one state that it be disclosed, while in the other there's a refusal.
Right. I understand, and I think the short answer to your question is that the Florida legislature, wisely or unwisely, it's not for us to say, chose to enact the uniform law, just like its 49 sister states did. And the legislature created this mechanism that said, in order for something to be material here, it must be deemed material first in Florida and then in the home state of where the witness is located. And that's how you satisfy the criteria for materiality.
But it doesn't provide a mechanism for removing this loggerhead.
I understand, Justice
Lewis. We could have circumstances, God forbid, that they're manufacturing the drugs for lethal injection. And we're talking about somebody's life.
I understand, Ed, but we're certainly nowhere near that in this case. First of all, Kentucky has never once said you can't have access to this.
Well, I thought that's the premise we're working on.
No.
is that the Kentucky courts have already ruled that this is not discoverable. I thought that's what you're hiding behind, basically.
No, sir. Well,
maybe entitled to legally hide behind that barrier. But
yeah, I respectfully I'm uncomfortable with the hiding behind.
Well, CMI again, but you're using a barrier that may exist in another state to find out.
Well, one can perceive it as a barrier, or one can perceive it as a right conferred upon a witness to defend against what in actuality has turned out to be hundreds and hundreds of subpoenas from around the state.
Well, when you're involved in this kind of business, I mean, that's part of doing that business.
But when the
When you are
mechanism-
in the process of providing the equipment to lock people in jail, you're going to have to expect, I mean, certain things may flow with that. Certain responsibilities may flow with that. I mean, do you think when you say what's fair, is it fair to let a company in some state produce, manufacture equipment that is producing false readings, causing individuals in a state to get locked up? You can't be arguing
No,
that.
I'm certainly not arguing that, Justice Lewis. What I am arguing is that there is currently two options. Either there is the uniform law or there is nothing in place. And if the legislature needs to, and if the concerns you're raising need to be addressed, then they should be addressed legislatively. In other words, for example, the legislature could pass a statute that said, if you are going to sell devices used in the prosecution of criminal defendants, you must prepare yourself to make available all of the components, aspects, the software, the source code, whatever it may be, so that they are available to citizens of the state of Florida. That's an easy solution to this particular problem. But the answer is legislative.
Isn't there, but this is what I've been struck by. The uniform law makes it so difficult because it envisions a witness is going to have to come from another state into Florida, which is quite onerous. So the burden is high because the requirement of having to come here to testify is a huge burden for a citizen of another state. When it comes to documents, I don't, and you started to say something about whether that Kentucky has allowed this. I don't understand, or let's just say the witness is located in another state, but they're not material, but a defendant still wants to take the deposition. They're not like the most important witness, but they're a witness. I mean, in civil cases, you go and there are procedures for issuing subpoenas in other states. Is there a commission here, and then you go to the other state. Is that, in a criminal context, isn't there a way to go into Kentucky and to take depositions in Kentucky of Kentucky witnesses of CMI without the witnesses having to come to Florida?
Yes, Your Honor.
And what's the process?
The process is the same way it happens under the civil. If you look under Rule 3.220, it talks about deposition subpoenas, and they're governed by the Florida Rules of Civil Procedure. The mechanisms are the same. There is a Uniform Deposition and Discovery Act, which Florida...
But that doesn't, does that apply to
Yes, Your Honor.
criminal cases?
Yes, as far as I'm
I
aware.
thought it said something in the rule. It said, except for subpoena, ducus tecum.
Ducus, because there's no mechanism for the production of documents. In other words,
So how do you do it in a civil context?
in the civil context, you get a commission. You go to the court of the state where the witness is located. You have a subpoena issued by that court, and the witness appears in that state.
Okay, so there's
for
not
deposition.
really, so I just want to make sure, because we're talking about as if that the principle here mainly is about how onerous you can make it to have, or whether you make it difficult or easy to require people from other states or witnesses to come here. But when it comes to documents, and going back sort of to the gist here, these are electronically available. Isn't the solution that you do produce them? I mean, it's not an onerous requirement, so what's the problem?
Again, I'm going to have to go way outside the record.
Well, I don't
again.
want you to go way outside.
That's my concern. I think the legal issue, what we're battling about here may appear to the rest of the world as spilled milk, but what it really deals with is the inherent subpoena power of Florida courts, and it's not an inconsequential issue.
I want to ask a question, if I could, during this argument, about the jurisdiction.
Yes, sir.
That was exercised by the district court.
I'm sorry, the district court? Oh, the second tier cert.
We're here reviewing a district
Right. No,
court decision, right?
I was still thinking trial court terms.
Okay,
Thank you.
well, okay, so I'm struggling a little bit with how they got to where they got to exercise the second tier cert jurisdiction. I think you make a pretty compelling argument on the merits here based on the authority from other states and the federal courts. But I'm struggling to find the clearly established statutory law that establishes the correctness of your position.
The way I answer your question, Justice Kennedy, is to say that I think what the 5th DCA was trying to do was address two situations. Concerns about perceived misapplication or of the service of process statutes under Chapter 48. Because as you'll recall, the 5th DCA pointed out that using the registered agent in this manner was contrary to the purpose and effect of those statutes.
How is that? I mean, I've looked at the text.
And with respect to...
I've looked at the text, and I understand that that may be the right analysis. But it's not something where you can just look at the text and say that that is clearly established by this text, is it?
By the text? No. By the interpretation of that text by all other courts that have examined the issue? Yes.
All other courts where?
Outside of Florida. And the Florida...
Does a district court in Florida get cert jurisdiction because of what, second-tier cert jurisdiction because of what some courts outside of Florida have said?
Because the Florida legislature has written into the uniform law a mandate that it be interpreted in accordance with the controlling interpretations of other jurisdictions that have enacted it. And if every other jurisdiction that has enacted the uniform law has said you cannot use registered agents in this manner, you must use the Uniform Act or the uniform law to acquire documents, then that interpretation by the legislature's own mandate applies to the Florida statute. And that's the analysis that the 5th DCA got into, because it saw a statute that had been interpreted in this manner. And then it sees one contrary decision that would continue to be perpetuated, and this was the second concern of the 5th DCA.
Should the 5th District be concerned about what is going on in other states in the face of, clearly there are a couple of decisions right here from the 2nd and from the 3rd, I believe, which are exactly contrary. So if there's controlling precedent, or
the problem,
wouldn't it be those decisions from the 2nd and the 3rd?
The problem is that with all due respect to the 2nd DCA and to my own home DCA, neither one of those decisions is on point. The 2nd DCA's decision in Landrum, unfortunately, didn't engage in the analysis that's going on here. The 2nd DCA applied the wrong standard of review. The 2nd DCA said in Landrum, you, CMI, a witness subpoenaed in a felony action in circuit court seeking first-tier certiorari review, are not entitled to have us examine whether General Motors was correctly decided, whether it's still viable law after 30-some-odd years. Instead, we are going to apply a second-tier certiorari standard on a first-tier case and say to you, well, listen, the trial court followed the only case it had. We're not going to question. Even though we're not bound by General Motors, we're not going to look at it. So the 2nd DCA...
Obviously, then they were agreeing to whatever extent with General Motors, and
the problem with General Motors...
I'm trying to decide how the 5th District then uses case law outside of the state of Florida in the face of case law, whether you agree with it or not, in the state of Florida.
Because the General Motors case was decided long before any of the prevailing jurisprudence from other enacting jurisdictions was handed down. In other words, when General Motors was decided, which, by the way, General Motors is factually an inapposite case. I struggle with the notion that the 2nd DCA thought General Motors was even remotely controlling when it was a subpoena issued by a state attorney conducting a criminal investigation of a company located in Florida with documents in Florida and with employees in Florida, none of which are our facts. Nonetheless, the Landrum court said, well, General Motors is on point. I disagree that General Motors is on point. And even if it were, I respectfully submit it is no longer valid law.
Are they, in GM, were they investigating GM?
It's not clear from the opinion, Your Honor.
But the issue, is just that you said something about the records. are the records, would it be different if the records were in Florida?
If CMI maintained an office here
It's-
and it kept its source code here, let's say because Florida Department of Law Enforcement
Required them to.
required it, then they're here.
Okay, so then the registered agent has nothing to do with it. A good
Well,
old
except-
subpoena issued to a corporation that has offices here and documents here is
Would have to
valid in
comply.
Florida.
Would have to comply.
We wouldn't go through the uniform law.
Correct.
So the state of Florida could, again, just as Justice Lewis said, could solve this by requiring that anyone that does substantial business in Florida with law enforcement agents be available to produce any documents that is needed.
Absolutely. They could require, they could even do it
Documents that are
probably,
needed,
they could
sorry.
even probably do it through administrative regulation. The Florida Department of Law Enforcement could enact a regulation that says if you're going to do business with FDLE, you must confer on FDLE certain rights. And that is the right to have access to all of these materials, et cetera, so that, again, they're here. Because we do eventually come back to the question, and Justice Quince, you turned to it early on in your questions, which is, what does the trial court in Florida do? It cannot send the sheriff into Kentucky to get these documents, or to get...
So what about his, I believe Mr. Harrison said that what the court did was fine them whatever amount
Again,
per
we're-
day until they were produced.
I disagree with Mr. Harrison's analysis of that case, and again, this would require me to go way outside the record.
Well,
And it's
we
difficult
don't want,
because
as we said, we don't want to do that.
Right, and I've litigated this for CMI in 30 different counties throughout the state of Florida, trying to address these issues. But
Which really brings to mind what Justice Lewis said. If you've got 30 counties, people going to jail because of this instrument, and there's no way to get to whether or not these
Yes.
instruments are giving false positives and people are hauled off to jail.
I see I'm running out of time, Your Honor. If I could answer your last point, and then I'll conclude. We're not suggesting that there shouldn't be, or that there isn't a mechanism for having access to this. No one, to our knowledge, certainly not in the last 4 years that I've been dealing with this, has ever invoked the uniform law to try to do this. The state attorney's offices have. They've gone to Kentucky. They've gotten certificates of materiality. They've gone to Kentucky. The Kentucky court has issued a certificate, and the case has proceeded. But that's not been done. There hasn't been a criminal defendant here, certainly not in this case, who said, well, in light of the...
So the statement that the Kentucky courts have said this is not discoverable because it is proprietary is not true?
No. First of all, you can certainly get around the proprietary problem by a confidentiality agreement. And we've never taken the position that we wouldn't produce subject to an appropriate confidentiality provision. So
But if and I know you're out of time, but on that issue, because it's important, the third district has said that this source code wasn't material, and that's not an issue in this case. So if we don't resolve it, we've got the third district saying that, again, if you were to use the uniform law, that the third district has said it's not material.
Well, I think the third DCA ruled that way in Bastos, which was, again, one of my cases, because the record that had been developed below did not sufficiently establish the materiality. So I'm sure that if criminal defense attorneys representing their clients, if they established the proper record for materiality, they would get a certificate. The certificate would travel to Kentucky. We'd go through that process.
Thank you for your arguments.
Thank you
Rebuttal?
for the court.
Hey, please, the court. One potential remedy for this logjam, as the court has indicated, is for the court to potentially amend Rule 3.220 to expand the discovery rights of defendants in cases like this. The CMI's distinction between this case and General Motors, I don't think, is persuasive. They seem to think that the fact that it's a state attorney subpoena is different than a defense subpoena. The issue isn't the authority of the issue to subpoena, is whether it's properly served on CMI. So I don't think that distinction's persuasive in this case. On second-tier cert review, the CMI has essentially asked the 5th DCA to read words into the plain language of Section 942. It's clear, and they've conceded, that the plain language does not address documents.
That would be, but then you're back to this problem. It clearly is, if there is no other right to get the documents, then it's a violation of the law because there's no other authority. And you say, well, no, the clearly established law is Section 48. But if we read it and say, no, that's for service of process for lawsuits, you get to the same. There's no basis. There's no legal basis to.
Your Honor, I agree with your premise. But my disagreement is I think the plain language of 607 provides the basis to serve the subpoena and Chapter 48. 607 says foreign corporations can be served pursuant to the rules in Chapter 48. So and foreign corporations are treated just like domestic corporations. All the liabilities, rights, and requirements are assigned to foreign corporations under Chapter 607. So it's treated just like a domestic corporation for purposes of service. So we believe the subpoenas in this case were properly served, that the 5th DCA overstepped its bounds on second-tier cert review, and that decision should be quashed. Thank you.
Thank you for your arguments. The next case for the day is Smith versus State of Florida.
May it please the court, my name is Richard Kylie. I work for CCRC Middle, and I represent Stephen Smith in this action today. I would like to argue issue 2 of the initial brief first. Mr. Smith did not receive effective assistance of counsel during the penalty phase of his trial, violating his 4th, 5th, 6th, 8th, and 14th Amendment rights under the United States Constitution and his corresponding rights under the Florida Constitution. I'd also like to argue issue 1. Mr. Smith did not receive effective assistance of counsel in the guilt phase of his trial, violating his 4th, 5th, 6th, 8th, and 14th Amendment rights under the United States Constitution and his corresponding rights under the Florida Constitution. Mr. Smith's trial attorney rendered ineffective assistance of counsel when he failed to object to the testimony that Mr. Smith wanted to rape a female prison guard during his escape attempt. The trial counsel was ineffective for failing to object to the introduction of evidence of an uncharged offense and an uncommitted crime. The probative value of said evidence was far outweighed by the prejudicial effect and deprived Mr. Smith of a fair trial. Now, in regards to Claim 2, the prejudice in Claim 2 is obvious and it is blatant. Due to trial counsel's ineffectiveness, Smith was deprived of a statutory mental mitigator. The post-conviction court's reliance on Assay v. State is an error because it is based on a misapprehension of fact. The court held that this was a favorable diagnosis. You cannot hire another expert to give a more favorable diagnosis. This was not a more favorable diagnosis. It was a complete diagnosis. The trial counsel ignored the fact.
Mr. Kylie, your argument seems to be premised on the fact that you say that the mental health expert who testified at the penalty phase was not given these DLC records. However, as I read this record, it seems to me that we have a question here as to whether or not he did, in fact, have those records. So what is your take on that?
Well, Judge, as cited in our motion and our brief, there was a colloquy given by the state's attorney saying, and did you review the prison records of Mr. Smith? And Dr. Sharif clearly said, no, I did not receive them.
But then he was called as a witness by the state later, correct? In rebuttal. So
Dr. Sharif?
yes.
No, he was called by the defense.
And
Now-
he did not say at one point that he may have had those records?
No.
Well, now, wait, what about in the post-conviction proceedings when he testified?
In the post-conviction proceedings, he still testified that he did not have it. Mr. Sullivan said he thought he gave it to him, but obviously he did not. He relied on the record.
Well, didn't he testify, didn't the expert witness testify that he did not specifically remember getting these particular records or not? He could not say whether he had received them or not. Isn't that correct?
No, he said he did not. Clearly, at trial, he said, I did not receive them.
Counselor, I'm asking you about his testimony in post-conviction, and I think you understand that. What did he testify to in the post-conviction proceedings? Now, look, we have the transcript here. You just...
Judge, I'm not trying to mislead this court. I believe he said he didn't remember whether he had them or not.
Okay. That's different than saying that he had not received them.
At trial, he said he did not receive them, sir.
Well, now, isn't it, at
He
trial, isn't
reviewed
the
them.
testimony, let me ask you this, at trial, isn't the testimony somewhat amorphous in that there's reference to, is it 1,500 pages of documents and not having reviewed 1,500 pages or a certain number, large number of pages of documents?
Correct, sir.
Well, and then there are questions about documents that related to the other defendants.
Yes, that was Mr.
So,
Sullivan.
I mean, I've read that, and it seems to me to be unclear exactly what they were talking about at trial. And certainly there's not a focus at trial on these particular records that are at issue here.
Judge, we attached those records that were not reviewed by Dr. Sharif to our motion and questioned him at the hearing. Now, Your Honor, what is interesting is Dr. Thomas Willingham, a psychiatrist retained by the state, deposed by trial counsel 2 days before the penalty phase trial, did review prison records and found an Axis 1, attention deficit hyperactivity disorder, polysubstance abuse by history, dissociative elements under stress, and pseudo hallucinations by history. And now we're contending that an Axis 1 diagnosis would have given rise to statutory mental mitigation as opposed to the antisocial personality disorder that they had tried to pass off as a statutory mental mitigator. Willingham was not called by the state. We are suggesting and assuming that effective counsel would have immediately placed this man under subpoena and called him as his expert, which he did not do.
Now, you also seem to be talking about the fact that post-traumatic stress disorder is an Axis 1 diagnosis, correct?
Yes, Justice Wentz, it is.
Didn't the doctor who testified at the penalty phase, Sharif, is that his name?
Doctor.
Didn't he also testify to some Axis 1 diagnosis? I mean, I
Dr.
thought
Sharif?
I remember him saying, who?
Dr. Sharif?
Yes.
The
Didn't
defense
he
expert?
testify to?
No, ma'am.
Wait, hold on. Let me
Yes, ma'am.
finish the question. Didn't he testify that this defendant had a depression, that he had ADD, substance abuse, and as I recall, I thought those were Axis 1 diagnoses. No?
Your Honor, respectfully, that was Dr. Willingham, the state expert, not called by the state, yet deposed by the defense before the penalty phase trial. Dr. Sharif found antisocial personality disorder only. Dr. Mayer found PTSD because it's replete in the records. A dissociative disorder, attention deficit disorder, pretty much what Dr. Willingham would have testified to had he been called by effective counsel.
Could you
in the state.
address for both of your issues prejudice? Because I'm having a real hard time seeing how, with the facts and his background, he was incarcerated for murder, right? He was in as having murdered, and what else? He had a pretty extensive criminal background.
Indeed, he did, Justice Pariente.
And then he participates in killing a guard.
Yes,
And a
well,
planned-
Judge,
And you don't have anything that shows that he wasn't as involved as the state presented at trial. So I guess my question is how could putting on some other mental mitigation have, how does that undermine our confidence? How can there be prejudice?
well, Your Honor, the defense tried to put on a statutory mitigation saying antisocial personality disorder.
Statutory mitigation?
Yes.
Well, how
And
is
this court
how can
rejected
there
it.
be statutory mitigation for a planned escape where it was intended that they were going to, I guess for one inmate, they wanted to get back at one inmate who had ratted on them and then kill a guard?
Well, Judge, there was no plan on killing the guard. Beatson,
Now, isn't there testimony, though? I understand it may be your view that best view of the evidence would not support that, but wasn't there some testimony that he had said, that is, the defendant had said they'd kill whoever they needed to, including the guard?
well, Judge, that may be braggadocio by one of the defendants. Mr. Smith clearly indicated, Judge, by your leave, I'm almost into my rebuttal. I would just like to briefly mention Claim 1, that the prejudice, not objecting to this uncharged crime, an uncommitted crime, is acted as a non-statutory aggravator. Without the statement that all the state had was Mr. Smith standing there trying to assemble a ladder which wasn't completed. The guard was not supposed to be killed that night. Tommy Englund, Mr. Beatson was beaten to death by Mr. Jones. Tommy Englund killed the guard. Mr. Beatson was supposed to take the guard in a full Nelson and throw her in a closet. However, all you have now, once Englund killed the guard, is Mr. Smith feverishly trying to put this ladder together with duct tape. These prisoners had access to welding material, and they were welding most of the ladder so it would go over both walls. Because the guard was killed when she was, and Beatson was murdered when he was, they had to go now. So without this inflammatory statement, all you have is Mr. Smith standing there and trying to assemble the ladder while Englund killed the guard.
So what is, your argument, I guess, and you're trying to save time, is that the sexual battery statement should not have come in because it would, but where is the prejudice? Let's do that portion of it. Where is the prejudice from that statement or statements coming in?
Well, yeah, Judge, it acted as a non-statutory aggravator. Without this statement, this horrible statement that was uncharged, uncommitted, and later on during his confession, Mr. Smith said, nah, we were
When
too
did this
excited.
come in the guilt phase?
Yes.
Okay.
Now, we're saying it acted as a non-statutory aggravator because all they had was Englund killing the guard, Jones killing Beatson, and Smith trying to assemble a ladder that was partially ready to be assembled.
Who was Likens?
Likens was an inmate who was transferred immediately after the.
So the statements that were these very,
Crude.
Very crude, inflammatory statements came in through an inmate Likens. He wasn't a co-defendant.
No, he was not a co-defendant.
Okay, who else did they come in through?
Yuloa was a detective that guided Mr. Smith through the walkthrough of the crime scene.
And Mr. Smith then said it to the detective?
No, the detective said, well, you were going to rape a guard, weren't you? And he said, well, the thought had crossed my mind. And why didn't you do it? And Mr. Smith said, well, once the escape got started, we were too excited, we were too upset. We were escaping from prison here. And he moved on. But the main
So doesn't
statement,
that really go, though? I'm struggling with it. It seems to me, if I were the defense lawyer, I would have at least made an attempt to object and move in limine to keep some of it out, but doesn't it also, there's an argument that it goes to what his state of mind was in planning for the escape and what he intended to do. I mean, if it's, you're not saying he didn't say it, you're saying it shouldn't have come in, but it sort of seems that there's a good argument that it does show what his motives were in helping to plan this, the escape.
Well, Your Honor, his motive was to escape. All the cases cited by opposing counsel involved an act, condi. Man abducted a prostitute prior to killing another prostitute. Lamarca, he was having sex with his daughter and killed a witness that saw him doing
But
that.
here, why is this not admissible when a defendant is taking the position, producing evidence, testimony? I was just a minor player, no particular individual, that it really didn't make any difference who the guard was. I just was going along following someone's lead, yet there is this other evidence about an active participation in a violent act upon a particular guard. Why does it not become relevant then for the jury to hear that? That no, you weren't just a passive individual, that you had a direct plan to harm a particular guard who was actually harmed.
Judge,
Why is it, explain to me, why that does not then become relevant for the jury to hear?
because Mr. Smith had not planned on anyone getting killed.
He had planned on a violent act against a particular guard. That's why it came in, wasn't it?
Apprehension of the guard and throwing her into a closet was Beatson's job. Beatson was killed. Tommy Eglin, who was an extremely unstable individual, when the guard came around a corner, just hit her to the surprise of Smith and Jones. And now, by your leave, ladies and gentlemen, I would like to reserve rebuttal.
Thank you.
May it please the court, Stephen Ake on behalf of the state of Florida. The trial court in this case properly denied the two claims of ineffective assistance of counsel. I'd like to, I guess, first address the claim as to trial counsel's alleged ineffectiveness for failing to move in limine to exclude the testimony regarding the rape.
I mean, let me ask you this. It seems that there's relevancy, but the use of the language that he used, supposedly used, is maybe beyond the pale, but with the defense lawyer not objecting, there was really no chance for the trial court to do a weighing. And I don't know that it's just such a slam dunk that every part of what he says comes in, because it's sure once you read that, you know, and he didn't do the killing of this person or that person, it just elevates it, in my mind, to that this is the most disgusting guy, you know, that have these thoughts. In other words, it's not, and so that's why I'm concerned that the defense lawyer said, well, I just assumed it was inextricably intertwined, as if it actually, they had actually raped her, or so. Well, tell me why he shouldn't have at least objected, and why maybe a balancing test couldn't have been applied to at least keep some of the more inflammatory parts of it, which I will not repeat here, to come in.
Right. Well, counsel who testified at the post-conviction evidentiary hearing was a very experienced criminal trial attorney, and his testimony was that he believed it would be a meritless motion, that he would not succeed on that if he were to file it, because based on his research and his knowledge, it was inextricably intertwined.
If we had defense lawyers based on they didn't think the objection would be sustained, I mean, you know, it just seems that this one is, I just find it, I mean, I guess we got to accept the fact that he said it wasn't a strategy, right? Wasn't a strategy.
No.
So if we decide it would be meritless, then there's no prejudice, whether he should have objected, right, just because it is so inflammatory. But would you make an argument that even with that in, I mean, could you explain?
Oh, definitely,
that
Your Honor.
If some of it should have been kept out, why it does not undermine our confidence in the outcome?
Well, first, I don't think you can parcel out any of it. I think what came in was the statement from inmate Likens. I think it was almost a direct quote from what Stephen Smith said. I would disagree with counsel somewhat and go try to correct the record a little bit, that inmate Likens testified as to numerous statements that Stephen Smith made. The night before the murder was he wanted to do what he wanted to do with the female guard and that he was going to kill her, and that did come out through Likens, and that was the night before the murder actually took place. I don't think there's any way that counsel could have tried to sanitize that, because it was relevant to his whole escape plan as to, we're going to go when there's a female guard because I want to rape her before I leave, and we're also going to kill the guard. That was all part and parcel of their plan as to when they were going to go, and that was a statement that inmate Likens said was made the night before the escape attempt. So trial counsel looking at that, granted, he could have moved in limine to exclude, but I don't think you can parcel it out. I don't think he would have been able to say, let's admit part of his statement. It's all coming in. And the other time it came in was through the videotape walkthrough with the FDLE detective. And in that case, Smith used some crude language, and the detective said, what do you mean by that? Correct, Your Honor. It's
Not the officer.
correct. And the terminology that Smith said as he was explaining in detail was a crude reference as to what he was going to do, and the officer just simply said, what do you mean by that? And then he explained what he was going to do. And his plan was...
Ask you this about those statements. It seems that the prosecutor, at least at a couple of 3 points during his summation, talked about those. And that part of it seems even more unnecessary to me. But why was the prosecutor actually talking about this supposed statement, these statements about rape, when we know that no such rape took place?
Well, I think if you read the entire closing, it's referenced twice, and the two references are to the two inmates, or to the two times it came out, one through inmate Likens and one through the officer. And the prosecutor uses a very sanitized, this is what they testified to, and it was relevant because it was going to his motive and plan to do this.
Is there a, if they had asked for a limiting instruction, would they have gotten one? I mean, in other words, that it's not a, it's an uncharged, not only is it an uncharged crime, but it's a disgusting statement. I mean, they may have. I don't know what the trial judge would have done had they asked for that. I don't think this trial judge would have excluded it had they filed the motion. I think this was going to come in as relevant, inseparable crime type of evidence under 90.402. I don't think the court would have excluded it, whether he would have given some kind of limiting instruction. It's all speculation. He never, I mean, one of the things, he never denied making the statement. No. Actually, he told the officer on video that he didn't say he made the statement to inmate Likens, but he said the same thing to the detective. But Justice Perriente, you asked me what would have happened even if this came in. Is there still some kind of harmless error? Certainly, there's the evidence. Well, not harmless error. We don't have to get to harmless
right.
error. We get to the higher standard of undermining confidence.
Right, and
it certainly wouldn't have been if it had been it wouldn't have been harmless error if it was erroneously admitted. No,
the post-conviction court rejected it on both prongs of the prejudice and said there's no undermining of the confidence in this case. And you have a defendant serving 4 life sentences, consecutive life sentences. Actively, he was one of the ringleaders of this escape plan. He was the one that brought in Eaglin into the plan. He was the one that, if you look at his videotape walkthrough, is very detailed as to what their plans were. The testimony from inmate Likens corroborated that, what's on the videotape, and it was basically, he said, watch the news. We're going to be on the news tonight because we're doing this big, when we have this female guard, we're going to kill her and rape her and escape. So we're going to be, on the news. So keep an eye out for it. So this was all Smith's idea. Now, Eaglin. Where
was it that he said, to Likens, what page of the record where he said both, we're going to kill her, we're going to rape her first and then kill her?
I have in my notes that it's around page 600 to about 605 maybe, in the direct appeal record, I believe. Somewhere in there. To go, and I would also like to kind of clarify some of the things on issue 2 involving the records in Dr. Sharif's records. Counsel did correctly say that at trial, Dr. Sharif was cross-examined by the state attorney's office, and he pointed to what I suppose is banker boxes filled with documents and said, "You didn't review these 15,000 pages of documents, did you?" And he said, "No, I didn't review that." Including in that is 2,000 pages from Department of Corrections, and he said, "No, I didn't do that." At the evidentiary hearing, he backed off of that and basically said, "Trial counsel gave me a ton of documentation, including DOC records from Rhode Island." He had Smith had a prior penalty phase, so Dr. Sharif had all the information from that. He had all kinds of stuff. And then he said, "I recall going to trial counsel's office or him coming to my office, vice versa, and reviewing some documents that he did not give me physical possession of, the DOC documents." So he was unclear as to whether he had actually reviewed these 85 pages of documents that were attached to the motion.
What was his actual diagnosis?
You were correct, Your Honor. He did diagnose numerous Axis 1 diagnoses at the penalty phase, including attention deficit disorder, depression, and substance abuse. His testimony at the penalty phase was Smith had all three of those Axis 1 diagnoses, but they were in remission at the time of the crime. Correct, Your Honor, yes. And that's in the penalty phase transcript also, that he did, in fact, diagnose those three. And his testimony at the evidentiary hearing was basically the post-traumatic stress disorder wouldn't have changed his opinion one bit. He said he may have included it in his diagnosis as something that was in remission, but he found no evidence that Smith was suffering from post-traumatic stress disorder at the time of the murders in this case. And he disagreed with the...
Did some mental health experts say he was suffering from post-traumatic stress disorder at the time of the murder?
The collateral expert that came in, Dr. Mayer, said that. That was his testimony.
And he based that on what?
On the fact that his testimony was that Smith had two stabbing incidents, one as a youth by his father and one in prison when he was incarcerated. And Dr. Mayer's testimony was that when the plan started and Smith observed the murder of the other inmate, that it basically put him in this post-traumatic stress disorder dissociative state. He said he had these...
And when was the murder of the other, that same night?
Yeah, the night that...
the beating death of the other inmate.
Correct. Basically the start of the plan into action. That's put him in this dissociative state that left him with paralyzing fear and anxiety. And of course...
Of course, that doesn't explain the testimony about what he'd said the night before.
No, Your Honor.
About what he was going to do.
Right, exactly. And
so I don't understand how that...
And it ignores the facts, too.
With the escape plan, didn't he?
Excuse me?
Even if you say he was in this dissociative state, he continued with the escape plan from that point, didn't he?
Right, correct, exactly. He went and built the ladders. He's the one that lured the officer to the closet, and he knew Eaglin was coming up with the sledgehammer when it happened. He put the officer in the closet and then went and built the ladders so they could do this escape plan. And there was no paralyzing with fear. And Dr. Sharif basically disagreed with that diagnosis and said, no, there's no evidence to support that. And so basically, they could show no deficiency, and the trial court made a factual finding that they failed to even prove that the doctor hadn't reviewed these documents, and they also failed to prove prejudice because Dr. Sharif testified, my opinion wouldn't have changed any. It wouldn't have affected them.
Could you explain, who is Dr. Willingham?
He was an expert that the state was potentially going to call in the penalty phase, but did not call. And really, this is the first I've heard of Dr. Willingham. This was never anything that was brought out. There was no claims involving Dr. Willingham. He was a state's expert that would have been rebuttal, and the thought that defense counsel would have called the state's expert I find surprising. But anyway, the state would ask this court to affirm the order from the post-conviction court. Thank you.
Thank you. Rebuttal.
First of all, Justice Kennedy, in regards to your question about the record, post-conviction record, volume 8, page 1372-1373, Mr. Sullivan concedes he did not give the DOC records to Dr. Sharif. Furthermore, Your Honor, in regards to Justice Perrietti, in regards to your undermining the confidence of the outcome, everyone forgets in all of these proceedings, there was a jury there. There was a jury there, and the jury came back 9-3. Without this statement, And with a statutory mental mitigator, we are contending that at least 3 people would have been swayed to vote for life. 3 people originally voted for life just based on Smith's horrible childhood. Now, Dr. Mayer stated in the post-conviction hearing, that when Smith saw the murder, he then experienced PTSD. Dr. Sharif in his testimony said, well, yeah, it's in remission now. And Mr. Shakur, I believe, asked him, would a violent act bring it out of remission? Yes. So that's pretty much where we stand. Now, we are saying that basically with Claim 2, it shouldn't have been in there. It wasn't a crime. It wasn't charged. It wasn't committed. And even if you want to nitpick, which I don't suggest the court do, any attempt at rape was abandoned. And as I said before, this plan went awry due to the actions of Tommy England.
Was there any other explanation in the record as to why they wanted a female officer?
Why they
wanted to commit this at a time when there was a female officer?
I don't believe so. However, she would have been more easily controlled to get into this secure closet. Beatson was supposed to do that. Beatson was supposed to get her in a full Nelson. She's a very large woman. Beatson was supposed to get her, and he was a very large man. Beatson was supposed to get her in a full Nelson and shove her into this closet when the time was right. However, Beatson was murdered by Jones, and they had to go now, or then, and the plan was to have the whole thing fully welded and ready to go. Instead, Smith was busy taping it. England was throwing the body into the closet, and they moved this makeshift ladder over to the fence, and England fell between the 2 fences. Basically, we're saying that Mr. Smith is guilty of felony murder, but he didn't rape anyone, and he shed no blood. And his death sentence should be vacated, and a new penalty phase should be ordered because of the ineffectiveness of counsel. I thank you for your time.
Thank you for your arguments. The court will be in recess for 10 minutes.
All right. Supreme Court is now in session.
The last case on the docket for the day is Brown versus State of Florida. You may proceed.
May it please the court, my name is Dave Davis, representing Mr. Thomas Brown in this capital case. Mr. Brown was charged with and convicted of one count of first-degree murder, and with a jury recommendation of 7 to 5, with sentence to death. The court found 3 aggravators, prior conviction for a robbery. He was on probation at the time of the murder, and the murder was cold, calculated, and premeditated. In mitigation, the court found 2 statutory mitigators, his age of 27, which it understandably gave slight weight, and under the influence of an extreme mental or emotional disturbance, which gave some weight. As non-statutory mitigators, the court found an IQ of 82. He was suffering from mental illness, and the victim did not suffer. Now, the facts in the case are that on June 18th, or perhaps better, on June 14th, Thomas Brown was working at a Wendy's restaurant in Jacksonville. There was the victim in the case was Juanice Miller. She was also working there. And on that Sunday, 14th, she dumped some water and ice down his back, apparently unprovoked. She was sent home that day, and the next day, the management of Wendy's tried to sort things out. She didn't come to work on Tuesday. He didn't come to court on Wednesday. And then on Thursday, the 18th, Brown comes to work, realizes his hours have been cut back, feels that he's being blamed for the incident, and being totally innocent victim in this case.
Yeah, and that, didn't you omit that there was some kind of actual meeting of all of them, and nothing, I assume the first incident took place on a Sunday.
Right.
At Monday, they all had a meeting,
Right.
discussed it all.
Yes.
And so nothing else took place until Friday, Thursday.
No, as far except that his hours were cut. When he looked at his hours, he realized his hours had been cut back, and he felt that because of that he was being blamed for this incident when he didn't have anything to do with it. In addition to this, Ms. Miller would walk around in his presence and say words like pussy, 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 pussy nigger, and that obviously upset him as well.
Well, that happened also on that Sunday, Monday?
I believe Sunday and sometime. It wasn't really clear when exactly she did it, although it was during this time. Well, on that Thursday, Mike Amami, who is a regional manager of the Wendy's, comes in. Brown wants to talk to him about what has happened, why his hours have been cut back. Unfortunately for Brown, what he thought this meeting turned into a shouting match. At some point, Amami then orders him off the property and essentially fires him. Brown storms out of there. And then comes back
How did they fire him? I thought he just told him to leave.
Well, it was pretty clear. He says, leave the property, I'm going to call the police. At least in Brown's, now, Amami at trial said he hadn't fired him, but it's pretty clear that Brown's days were numbered at that restaurant, that he, in fact, had thought he'd been fired. So he comes back, leaves the restaurant, comes back 45 minutes to an hour later, looking for Amami. And that's something the trial court found. Amami by this time had left. Juanice Miller is just gotten off shift. She's now standing in line waiting to order some food herself.
As you're going through this, I just want to make sure, you've agreed that the state does have sufficient evidence for the finding that Brown had the heightened premeditation.
Yes.
So
Yes.
what we're really focusing on now is
Cold and calculated. Cold and calculated.
And you agree that we have rejected the idea that there can be cold even if somebody is really upset.
You and Evans, and I think that's maybe what your heart alluding to. In Evans, you said that the trial court it's possible for a trial court to find the aggravating factor that at the time of the murder he was under the influence of an extreme mental or emotional disturbance, and the murder was committed in cold, calculated, premeditated. I think that may be what you're alluding to.
So I guess with a situation where it's not, there was no, he came back, I guess, to maybe kill the manager. Is that the idea?
He came back to kill Amami. That's what the trial court found. And that's not, the evidence supports that.
All right. But then he left.
He goes back, gets in his car, starts it up, stops it, and then comes back in.
Decides that he's going, and he doesn't just, she doesn't say to him something like,
she
doesn't
totally
say anything
unaware.
to taunt him.
No, she's totally unaware.
So what part of this isn't cold? I mean, I'm just,
Because
what does he say when before he kills her.
He doesn't say anything before he kills her. After he kills her, I guess, well, he shoots her 4 times, walks out, walks back in, shoots her again in the head, and said, I told you I'd kill you, bitch. That's what he said after, I guess, after the
So
final.
I'm, in terms of the judge's finding of all the elements, I'm having trouble understanding how this doesn't fit into CCP.
Well, okay. First of all, really the only fact supporting the cold aspect is the judge said he came back and appeared cold. Everybody
You don't have
else.
to appear, but that's the whole thing. The cold thing is that it wasn't a heat of passion kind of.
Oh, it certainly
reflective.
was. It certainly was. I mean, it was clearly a heat of passion for him, because when you look at what Dr. Kropp and even the state's expert, Dr. Ramaswamy, says, he is very, very angry when he comes back in. He's got a very much of an impulsive personality problem. I mean, that's even from the time he was 16 years. Every psychologist has looked at him said he is extraordinarily impulsive. Besides being psychotic, he's hearing voices, or not really psychotic. He's a psychotic sort of disorder. He was depressed, and Dr. Ramaswamy says he's borderline. He's got antisocial person. So, but he comes in there. He is very,
Well,
very
what if he
angry.
had come and just killed? What if the manager had been there? And he killed
I'm sorry,
the
had been there?
If the manager had been there and he killed the manager, he was obviously upset by what the manager said. Would that not have been CCP?
I would have a harder time making the argument.
But I guess
okay,
it seems. So what is the idea that nothing else has happened to get him? I mean, he could have left, and he makes a decision. I'm going to still come back and kill somebody.
Well, no, not somebody. I'm going to kill Miss Miller because of what she had done, and that had really torqued him off. It had really upset him, and in fact he did when he found out Amami wasn't there. He leaves, gets in the car, and then his 2-watt brain realizes that Miller's still there, so he parks the car, gets back out, and shoots her. I mean, it was clearly an impulsive action what he did in killing Miss Miller.
I mean, the evidence indicates that there's no knowledge of Miss Miller, and that he goes and meets with the manager inside the restaurant where she's located, and then somehow, after he's in his car, then becomes aware that she's in the restaurant. Is that somehow the evidence?
It's either in the car or probably on his way out. He may have seen her because she was standing in line waiting. She was off shift. She was standing in line to get some food. He may have recognized. It's not clear when he recognized she was there.
Well, again, it's not necessarily. We don't know. He didn't know she's there from the get-go.
Well, you don't. I mean, are we going to start
Well, all right.
speculating?
Well, you're making. I'm trying to understand where we are on the evidence, because
yeah,
I was not aware of that.
I mean, he was on shift. Let me say this. He had been on shift at the time. Miss Miller was also on shift because she was getting off shift when she ordered the food. So they were both on shift at the same time.
So they're both there. I mean,
Right.
he knows she's there.
But then why? If he's going to kill her, why does he walk out the door and then come back?
I don't know. I'm just trying to get the evidence straight.
Well,
Is that
okay,
they're
I'm
both
sorry.
there to say that he discovers that she's there after he gets in the car. It just seemed
Well,
contrary to everything that I had read.
Maybe that's maybe not discovered, but maybe recalls that she's there. Maybe that would be a better, more accurate way of saying it. No, if I said discover, that's probably.
But doesn't the evidence here support the conclusion that his primary purpose in going back was to get the manager?
I think, and that's what the trial court found.
And because the manager, he thought he'd been fired, and he was coming back to settle that score.
Right.
But he had other scores to settle.
Well,
and I think that's what, I mean, you get this kind of, you look at what happened, and he's probably disappointed that the manager's not there, but then he's reflecting, I've got this other score, I can settle now, and because she's likely to be there, and the victim in this case was that score. But the notion that somehow, the notion that because he had some anger, which is obvious, that can't be CCP, I don't understand that, because we've never said that the fact that a defendant is angry precludes a finding of CCP.
Well,
and I don't really understand your argument that you'd have a harder time arguing that if he had murdered the manager, that wasn't CPP, than you do arguing that the crime that actually happened.
Well, I mean, he clearly came in there intending to kill Amami. And then, like I say, he left.
Well, when he came back.
He came
He
back.
left, and he came back. I believe he was intending to kill somebody.
Well, he came back because, not somebody, he was intending to kill Miller because of what he put her at fault. And I'll be honest, this is one of the few victims I've had that doesn't come into this thing with clean hands, because she provoked him.
By putting ice down his back and saying some dirty words to him, that's a provocation to murder?
No,
This happens days before?
I didn't say that. I said it provoked him. It provoked the anger.
Well, again, and I guess if he had had a gun with him and at work, and she started saying these horrible things to him, and then he just goes, I'm going to kill you, you'd be closer to, first of all, not having the heightened premeditation, but that what we've said is that the killing has to be a product of cool and calm, doesn't have to be logical, because if logic was in here, rather than an act prompted by an emotional frenzy, panic, or fit of rage. When there is 4 days in between the provocation, that is like, again, the difference between somebody coming in and seeing their spouse with somebody and killing them, and it's not CCP, versus that they saw their spouse with somebody and 4 days later they came back, which we've had, and they shoot the spouse and the spouse's paramour. I just don't see that it is that you can meet, may not be the total cool and calm, but it's not an act prompted by an emotional frenzy, panic, or fit of rage as we would use that, which was designed, in my view, to be something that was the immediate provocation and then the killing.
Here's what happens. He gets in the fight with the mommy, or the argument with the mommy. That is, he's got a hair trigger anyway. He tends to act irrationally, impulsive anyway. He gets angry very, very quickly.
But he managed to live most of his life without killing somebody.
Well, let me finish here. But he gets, and he's working a minimum wage job. He's now been fired from it. And now he wants to come back and kill a mommy. And that's the provocation. And then what he does is he walks out and he realizes it's Miller that really has provoked this whole thing.
That makes see, you think that makes it better. I think it makes it worse.
Well, but he gets provoked easily. I mean, he all this stuff comes back to haunt him. The unfairness of the whole thing.
So you mean if he was somebody where someone had cut him off in traffic, and he was really upset because he couldn't get where he was going, he went back, got a gun, and shot the person that cut him off in traffic, that would be not cold calculated?
That's not the facts of this case, because what we have is 4 days earlier something provoking him to a steady decline in his status at that job. He's written up. He's blamed for something he didn't do. He's being blamed. He's being punished. His work hours are being reduced. And then when a mommy comes down and essentially fires him, that's it. That's the whole thing blows up in his face. And then he wants to kill a mommy, but then really he comes back and says, Miss Miller, with her taunting and the fact that she started this whole thing. No, I'm not saying it justifies it. Absolutely not. And no longer even a moral or legal justification.
What does he do after he shoots her?
Gets in his car and drives away. He's arrested the next day.
Does that have anything to do with what his state of mind was? That it wasn't like he goes, oh my God, I mean, he walks away and drives away. That doesn't further show the coldness of what he did? I mean, it's like a contract, someone...
Doesn't he muse about it in his little diary there?
Well, he mentioned that he killed her, yes.
Well, but it doesn't also mention that after he fired the first 3 shots, he walked away and goes back and said, I told you I was going to kill you, effing bitch.
Right.
And shoots it 2 more times. And then it says, now you go and tell Mike, thanks. I mean,
I don't recall
doesn't that indicate that he had already planned to kill her?
No.
Well, why did he say that he told her, I'm going to kill you?
Well, people can think of things on the spur of the moment.
Oh, okay.
That's kind of what I'm looking at. I mean, there's no indication that, and even what he said afterwards, that's no indication what his thought patterns were at the time. We don't see the calculation. We just don't see. I mean, the idea of the calculation is you're planning something. Here he walks in there with a gun. He walks into a restaurant which has got an abundance of people. There's either patrons or employees, all recognizing. There was no question that he killed her. I mean, he didn't take her body out and hide it. Didn't hide the murder in some way. Didn't try to escape. He just left. So,
How could he hide it when the restaurant full of people?
pardon me?
The restaurant was full of people.
Right. So, I mean, that's how, I mean, where's the calculation here? I mean, the idea of calculation is you're trying, you're trying to hide what you're doing or hide the fact that, he didn't put a mask over his face.
Calculation was, I told you I was going to kill you, and he did.
Well,
After he had pumped 3 shots into her, he fired 3 and 4 more while she was laying down on the ground.
Well, maybe as well. When did he tell her that? I mean, that's that we heard, but we really don't know when he said that.
After he fired 3 shots.
Yeah, but it's as like he has told her that before, but we don't know when he may have told her that before, is what I'm saying.
Okay.
Does it
Well, I
matter
guess she's
when he
dead.
told
She
her
can't
that
tell
before?
us.
I'm sorry?
Does it matter when he told her that?
Well, I mean, the implication that Justice Perry is getting the implication that he planned this because the inference being, I'm assuming that Justice Perry, that when he said, I told you I'd kill you, he had said that before.
But no matter
I
what
think
that
she did too.
implication is, does it matter when he said that?
Well, I think so, because that kind of goes to the idea of calculation, that you're planning things out. And here there's absolutely no planning. This guy is impulsive. He's been known to be impulsive since he was 16 years old, and his entire life has been one episode of DSM-4 come alive.
Didn't
from
he tell
this-
his mother when he went an hour before he came back, I'm going to go back and do something dangerous at the Wendy's?
I don't recall that. You may, I just don't recall it.
Well, there's testimony that she called Wendy's and told his girlfriend there that he's going to come back and do something dangerous.
Your Honor, I don't recall that.
You
You
don't
may be
recall
right.
that?
You may be right. I'm sorry. I just don't recall.
But I mean, again, I think you've agreed that he was coming back to kill somebody. Specifically, you're saying, well, it was the manager. The manager wasn't there, and then he leaves and he says, well, I can't kill the manager. I'm going to kill this bitch that has been harassing me 4 days earlier. I'm coming back in, and I coldly shoot her, and then I leave.
Well, I mean,
But again, you agree that when he came back to kill a victim.
To kill a mommy. And when,
Okay.
when a mommy's not there,
He leaves.
He leaves, gets in his car, is starting to back up, parks the car, puts the car, and comes back in and
And
shoots me.
what is it at that point, which is from the time he has his gun, he realizes that either he's coming back what if he came back and he killed somebody that was in the restaurant? Just to say, you know what, I think Wendy's is, I'm just going to kill
Right.
somebody else. What would that be?
Well, I mean, just to spur of the moment off the cuff.
No, he's coming back in. It's pretty clear he comes back in to kill somebody.
To kill a mommy is what he initially
But
wanted.
when the guy isn't there, he leaves, and that's when he makes a decision in the car. I'm coming back in to kill somebody, right? I mean, that's the only.
He's coming back in to kill Miller. That's what he's planning on doing.
Well, then you really have the heightened and cold.
Well,
'cause
like I
it
said,
goes,
I don't-
let's see let me think who has offended me in my life. I think I'll come
that
back
goes
and
back
kill
to the
them.
cold. I mean, you're divorcing the idea that this guy is impulsive. He's irrational. He is not thinking straight, obviously. But I mean, the fact that he can't find one victim, so he's going to find another. I mean, takes it out of the calculated aspect.
Well,
We don't
any of this, even killing the manager, it's obviously at a proportion to what happened. If we had, for a death penalty requirement, that somebody be like equal to the average person, we would never have a death penalty.
I understand, but what I'm saying is his mind. I mean, when you look at his, and this is why when the judge blows off the fact that he was under the influence of an extreme emotional disturbance, because as participating in the CCP, I think that's the same problem you're getting into here. That definitely had an impact on his ability to coldly and calculatedly plan this murder, and that's what we're saying here. Let me move on to the proportionality. When we look at whether or not this is the most aggravated and least mitigated, there is a ton of mitigation here. This guy has been, like I say, this man has been diagnosed with severe problems since he was 16. That in fact, they were suggesting he should have been committed at 16. They said that he was paranoid, he was hallucinating, hearing voices. And then Dr. Kropp and Dr. Ribasamy, essentially, they differ somewhat on the IQ, but he does have a low IQ. Not retarded, unfortunately. Well, at least from our aspect, it's not reported. But in any event, that he's got some significant problems. He's like I say, he's got a psychotic disorder, not otherwise diagnosed. or specified rather. He's also has got depression, not otherwise specified, and he's got this extraordinary anger that even Dr. Ribasami says.
But, I understand all those things, and those are things that I think it's appropriate for you to bring up. But we also have the picture here. This is a fellow who's on parole. Our sister state of Georgia had seen fit to place him on parole, and he was still subject to parole. The state of Florida saw fit to take supervision of him, and he had stayed on parole. He'd not violated his parole. Now, knowing how these things work, I mean, it's pretty easy to violate your parole if you're a totally out of control person. And he also, I understand he's got lots of issues in his life, but he's got lots of romance also. It seems like he's got
3 girlfriends at one time.
He's got all these things going on, and he's able to keep. And he's one of them is the assistant manager at the Wendy's. So he is. There's an element of control in the midst of what you're telling us about also. Isn't that true? And what didn't the trial court properly focus on that?
You know, one of the real problems I have when I come talk to the court is I get the feeling that unless the guy is totally bonkers, totally insane all the time, then these mitigators don't really have much weight. But these guys can get out. I mean, people who have got legitimate mental problems don't necessarily there are times when they can control themselves, and particularly some people when they have proper medications can. And what happens in this case was so aberrational from the daily flipping hamburgers routine that he had. He had this woman who had done this thing to him, who was now in the process of getting him fired, and that would. In a man who's in a very minimal existence already, there's not a lot of safety nets for him out there. I mean, he's at a minimum wage, he's losing that. His life is going to take a tragic change. So this is a big change. In the prior 14 months, apparently nothing of that magnitude had happened. Now, I'm not saying Ms. Miller absolutely deserved it, what she got. Absolutely not. Nobody would have deserved that. But what I am saying is she triggered this whole, I don't want to call it a psychotic episode, but there were some elements of losing contact with reality here. And this is what's going on with Mr. Brown, is he has got some significant mental problems that, in the balance of things, outweigh or not outweigh, but have a greater concern than the aggravation. Now, the last issue I'd like to talk about is the chestnut issue, and I've taken a lot of flack from you this morning, and I suspect I'll take a lot more with this issue because you have, in chestnut, you said that evidence of less than insanity is irrelevant in the guilt phase, and that's what you basically say. And you've, as recently as Nelson in 2010, you basically followed that line. What I'm asking this court to do is, in a case like this, a capital case where the man's facing death, and the state is seeking the CCP aggravator, that you should withdraw or modify chestnut to the point where, if particularly when the state is seeking death and they're going to use the CCP aggravator, that evidence of the defendant's mental capacity or mental state less than insanity should be admitted in the guilt phase. And I do that, and I say that for one fairly obvious reason, because in chestnut the rationale was that evidence of the defendant's mental state less than insanity just too confusing, too misleading to the jury. But in this case, that evidence was excluded, but then we turn around in the penalty phase, and the very same evidence comes in to prove heightened premeditation and the cold calculatedness. So it doesn't make a lot of logical sense to exclude the evidence in the guilt phase, but not in the penalty phase. So I'd ask this court to...
And what purpose is it going to serve in the guilt phase?
To show a lack of premeditation, that he... Well, to show that he could, because of his mental instabilities, did not premeditate the murder.
You want us to say that if you have a diminished capacity, you cannot premeditate?
No, I'm not saying that. I'm saying it becomes evidence the jury can consider, and the defendant can...
You're not saying that. You're saying what?
I'm saying... I'm not saying that. What I'm saying is the defendant's mental state less than insanity, if he's paranoid, almost psychotic, that evidence can come in to show a lack of premeditation. and it's relevant to show that. Now, whether the jury believes it or not is another thing, but you certainly should be able to get a jury instruction on it.
But since in this case, you have agreed that there is there's not only enough for premeditation, for heightened premeditation, I'm not sure this is the best case to revisit it.
Well, I think, again, you may not believe it, I may not believe it, but that's not the question. The question is can we present evidence to convince the jury to believe it? And under any evidence standard for a jury instruction, that evidence should be admissible. Okay, thank you very much.
May it please the court, Meredith Carbula, Assistant Attorney General for the appellee in this case. If I could just briefly touch on the chestnut issue. This court has, adhered to chestnut for the last 20 plus years. But what I would say in this case, Justice Pariente, I think you hit the nail on the head. This is certainly not the case to revisit that, if this court would ever choose to revisit that, because number one, it wasn't preserved for appeal, because he didn't proffer any evidence that the defendant lacked the capacity to premeditate. And that's a requirement. If the issue is exclusion of evidence, you have to proffer it. And both Dr. Ribsami or Dr. Ribsam, I'm not sure how to pronounce it, and Dr. Kropp testified that the defendant his capacity to appreciate the criminality of his conduct and to conform his conduct to the requirements of law was not impaired. So I think that any chestnut error would be harmless because the defendant offered no evidence that he lacked the ability to premeditate. So I think insofar as the chestnut issue, there is no chestnut evidence in this case, so this would be a poor case to choose to revisit chestnut. Insofar as the cold, calculated, and premeditated, as Brown has admitted, the heightened premeditation, I couldn't disagree more with Brown's assertion that there was no evidence that he told her that in advance that he would kill her, because I think evidence, I told you I would kill you, you effing bitch, is evidence that he told her that he would kill her at some point. All the testimony that the two worked together on shift at Wendy's that day, that morning, and that there were no words between them. So I think that that's certainly evidence that he told her.
Let me see if I make sure I understand this. They actually worked on the same shift on that day.
That's correct. In close proximity to each other.
And there was no evidence of any confrontation between them. There's no evidence she said anything derogatory to him that day, or that they had any kind of confrontation.
No one else saw any kind of words exchange between them or any confrontation. Brown did tell, I think, Dr. Kropp that she had taunted him when he came in that day, but nobody heard that. People were working in close proximity, and they saw no confrontation, no words, no trouble between them. So I think when you look at the admission of heightened premeditation, you also look at the calculated. And the calculated, this court has held that there's competent substantial evidence to uphold the CCP aggravator. And I think, just to step back a moment, the fact that there are potential other versions of the defendant's state of mind does not defeat competent substantial evidence. And that's the standard review this court applies. And here we have an execution-style murder, 3 in the back, a walk away, a comeback, and a coup de grace, a vicious last shot to the head with the I told you I would kill you statement. And that was heard by several people. So we have this execution-style murder. There was no contemporaneous provocation established, and the trial judge so found that there was no contemporaneous provocation. The incident with the horseplay, and the witnesses who were actually there described it as horseplay, where had occurred on 4 days before the murder. The meeting where the victim had taunted him, and I think the record doesn't support any notion that she continually taunted him. This happened when she called his manhood into question, as well as made a racially derogatory remark. That was shortly around the time of the meeting where they were both getting called into the carpet for the horseplay incident the day before. So I think it's important to wipe the mirror clean to show that this is not an ongoing taunting of the victim. And there was no evidence that anything happened between Monday and Thursday. In fact,
they didn't even work together between Monday. I mean, on Tuesday, one of them worked. On Wednesday, one of them worked, and they were not back together again until Thursday.
That's very, very true. They were not back together, but the evidence is still that he had essentially 3 days in which to any of the sort of heat of passion to calm down insofar as his anger toward her.
I don't know if the record indicates that, but he left after his confrontation with the manager, and the manager told him to leave the premises. He was gone for about an hour or so. Do we know if he procured the weapon at that time, or we don't?
My recollection is he told Dr. Kropp or Dr. Ribsami that he went back to his apartment and got the gun and then came back to the Wendy's. So he drove his own car, he went back to his apartment, he retrieved a .40 caliber pistol from his apartment and returned to the Wendy's armed with the firearm. And so I also think it's important to recall that Angela Hartley, the person who knew him best, testified that when he returned in to kill Ms. Miller, he was cold. That's how she described him, as cold. And he very well focused on Miss Miller. There was no evidence of a frenzied, I'm going to shoot up Wendy's. He walked right up to her with her back turned to him and shot her 3 times in the back, walked away. Witnesses described it. He started for the door, he came back, and then he fired an additional shot into the back of her head and told her just exactly what you said, Justice Barry. I told you I'd kill you, effing bitch, and tell Mike, thanks. So we have evidence supporting this, the competent substantial evidence supporting the CCP aggravator, and this court should affirm. And insofar as the proportionality, I don't think there's any doubt. In fact, the trial court, Judge Centerfit, found the extreme emotional disturbance based on the testimony of Dr. Kropp. But she only gave it some weight because Dr. Ribsami believed that he wasn't under the influence of extreme emotional disturbance at the time. But she did give the aggravator, she found the aggravator giving it only some weight. And I think when you look at, Ms. Harley testified that she perceived his mental status was deteriorating in the days before the murder, in the last 30 days. However, the parole officer, and he was on parole as opposed to probation from the robbery that he committed in Georgia. And we have to remember he committed a robbery in Georgia. The victim came in and testified that he held a gun to her head, and he pled to the robbery, was sentenced to 10 years in the Department of Corrections. Georgia Department of Corrections, was paroled 14 months before this murder. And Justice Kennedy, you're absolutely right, is that he had complied with the terms of his probation for 14 months. In fact, he had told the one of the mental health experts, I believe it was Dr. Kropp, that he had intentionally stopped using marijuana because he did not want to fail his probation in his parole. So he didn't want to violate his parole, so he intentionally took steps. And I think you can see that that's evidence that he is not in some sort of, psychotic fog in which he can't make decisions. And so and Justice Perry, what he did was he got into his car, he drove into Georgia, he stayed in Georgia, I think, overnight. He came back to Florida the next day. So he did. And Dr. Ribsami talked about his escape plan, and so he did flee into Georgia, and then he returned to Florida, but he didn't return home. He returned to a hotel room where he was subsequently apprehended, and also he did tell his mother. His mother didn't testify against her son at trial, but what we do know is that he talked to his mother. He told her he was going back to Wendy's, or at least he gave her the indication he was, and she called Angela Harley and asked her to stop him.
How do that information get into the record?
Ms. Harley testified to it, that she got a call from Brown's mother, that she was waiting for him, and that she tried to stop him on the way into the Wendy's. We also have the parole officer insofar as his demeanor. Between the time of this meeting and the time of the murder, parole officer met with him just 2 days before the murder and perceived that he was not having any kind of mental health issues, seemed to be fine. As she described, he was working and getting his life together. So the trial court found that evidence more credible than Ms. Harley's testimony that she perceived some sort of mental deterioration. So factoring in the CCP, one mental mitigator, this court has said that the prior violent felony is one of the most weightiest in Florida. So we have two very weighty aggravators. And so the case law from this court, Diaz, for instance, supports the fact that this sentence to death is proportionate. And if this court doesn't have any more questions, the state would ask that you affirm the convictions, the defendant's conviction for premeditated murder and the sentence to death.
Thank you. Ronald?
Well, I think the court has a good idea what's going on with the case, but I do want to go back to what Justice Kennedy, I kind of get the feeling, is that Brown has got some significant mental problems. They are not evident all the time, and this can be typical of people with mental problems. You're just not necessarily crazy all the time. People can use a lot of psychic energy to keep themselves under control. But when Michael Mommy fires him, and for what he perceives to be an unjust, unfair reason, then that triggers it. And he can have been perfectly okay 2 days earlier when the parole officer came and saw him. But when Michael Mommy fires him, and for what, like I say, for what he perceived to be unfair and unjust, he storms out of there and is in a rage. And everybody, even Ms. Harley, will say that he appeared very angry. Dr. Ribsami said he was very, very angry. And Dr. Kropp said the man should have been committed because of his mental problems. So I'd ask the court to reverse, at least if you follow me on the Chestnut issue, to give him a new trial. If not, to reduce his sentence to life in prison. Thank you very much.
Thank you for your arguments. Court is adjourned.
All rise.